Hello, my name is Rob Sterne, and I'm a founding partner of Sterne, Kessler, Goldstein Fox, an IP specialty law firm in Washington, D.C. It is March 2014, 18 months since the America Invents Act new contested proceedings became operational. I am the editor-in-chief of Patent Office Litigation, the first and what many consider the definitive treatise on the new patent enforcement, licensing, and monetization world in the United States. So much has changed in this world in 18 months, and the rapid change continues. If you are an entity targeted or sued by a patent owner of any type, an investor group, an individual inventor, R&D lab, startup, emerging company, university, government agency, larger enterprise, or a direct competitor, you must consider the use of one or more of the new contested proceedings under the America Invents Act as your optimal defense strategy. There are 10 topics you need to know to be effective using these new contested proceedings in this new patent world. I base this and my other observations that follow on extensive professional experience in this new contested proceedings world. As an attorney who specializes in these new contested proceedings, currently I and my firm are involved in over 100, which may be more than any other firm in the United States, and we have devoted more than 20,000 hours of attorney time on them to date. And as a patent office litigation attorney who defends many falsely accused patent infringers, as well as highly innovative patent owners in these contested proceedings, I can tell you that the district court trial bar often does not understand and embrace the great potential of this defense strategy over fighting the suit in the courts. Second, I and other highly experienced contested proceedings practitioners often tell accused infringers that these contested proceedings are 1/5 to 1/10 the cost of district court litigation, at least twice as fast, and much more likely of success in invalidating the claims. So consider these fundamental advantages. Third, more than 1,000 of these new contested proceedings, inter-party reviews, and covered business method proceedings have been filed since September 16, 2012, and the rate of filing continues to go up. More than 80% of these proceedings involve parallel litigation in the courts, and around 75% of the patent claims challenged in a filed proceeding are instituted for patentability trial by the Patent Trial and Appeal Board, and this rate is holding steady as the board has become more strict on the required showings in the filed petition. And the success rate for a finding of patentability of the challenge claim is surprisingly low, much to the consternation and disappointment of patent owners, based on the several dozen board final written decisions that have been handed down so far. So these new contested proceedings pose a very real and radical threat to patent owners of all types, and many patent owners have not woken up to this threat. Fourth, these proceedings can be settled and the proceeding terminated by the board. This is a very valuable tool for the accused infringer to use against the patent owner to resolve the dispute early and at low cost. The window for termination of the proceeding closes rapidly after trial on the challenge claims is instituted by the board. Savvy accused infringers use this window for early settlement. In fact, I have used this successfully in several cases and know from experience the impact of this tool is profound. It also creates a reduced threat for many patent assertions, producing substantial cost savings for accused infringers. So use the threat or the filing of a contested proceeding as standard operating procedure early on in a patent infringement or licensing situation. Do not allow your trial counsel to dissuade you from use of this powerful tool. Fifth, many trial counsel argue against use of contested proceedings due to the broad estoppels they create in parallel district court cases. This is especially true for inter partes reviews. But as a practical matter, and with the chances of success much higher for the accused infringer before the board, and the district court's deference to the patent office, many believe this reluctance to use these new contested proceedings is overblown. Sixth, many courts are staying their suits pending completion of the contested proceedings. Stays depend on the discretion of the district court judge. Certain districts are staying with higher frequency than others. If the contested proceeding trial has been instituted by the board, particularly for all of the claims in the district court suit, the probability of a stay goes up. So substantial advantage and cost savings can be obtained by the accused infringer if a stay of parallel district court proceeding is obtained by the filing of a contested proceeding. Seventh, the proceeding before the board are radically different in burdens of proof, scope, and process than comparable validity challenges of claims in the district courts. Few attorneys have substantial, deep experience before the board. And the board panels can be very rough on inexperienced counsel who often make fundamental mistakes in these proceedings. And it is very problematic to try to obtain reversal of these mistakes on appeal to the Federal Circuit due to waiver and the agency and substantial evidence review standards. While trial counsel can appear before the board, it is often a mistake. The accused infringer must carefully weigh who is the best attorney to bring the contested proceeding before the board and the Federal Circuit. Eighth, many mistakes are made by accused infringers in these contested proceedings. A deep understanding of the rules, the many hundreds of board decisions on key issues, the facts, the law, and the ability to prove the case using experts and other sources must be brought to bear long before the actual petition is filed and the trial is instituted. The process is totally front-end loaded, and full and complete proofs and showings must be made in the filed petition. Supplementation of the record is very problematic and often is impossible. And inter-party reviews must be brought within 1 year of service of suit in the district court. This time window is often missed by accused infringers. So a very informed and highly experienced contested proceedings counsel can prevent mistakes being made that often are fatal to the petitioner. Ninth, the statute requires completion of the trial within 12 months of institution or 18 months in exceptional circumstances. The board is adhering to this timeliness with single-minded focus. In fact, the current scheduling orders require all stages of the proceedings to be completed by the parties within 7 months of the institution of the board trial. There are no extensions of time. The contested proceeding team cannot be distracted by other proceedings, such as district court suit or an International Trade Commission investigation. Failure to realize and meet the rapid schedule and the unavailability of extensions of time has often proved fatal for petitioners. Do not, I repeat, do not fall into this trap. And finally, 10th, this is a rapidly developing specialty in patent law. It requires full-time focus by the attorney team. They cannot dabble or have their primary focus on district court or ITC litigation or patent prosecution. Trial counsel and patent prosecution counsel, frankly, often convinces the client that they can effectively handle these contested proceedings. My experience and the experience of other highly experienced Contested Proceedings Counsel is that this is not the case. Use a specialist with deep knowledge and experience before the board. I know this sounds very self-serving, but it's just prudence. Think about this. Would you want your surgeons operating on you on a potentially fatal operation if they were not specialists in that operation, having handled many of them successfully? Of course not. And the same ideal applies to these new contested proceedings. Thank you for your time and attention.